It does not make any sense. I can make all the money off your likeness, and the moment you decide to make some money off your likeness, you can't play here anymore. You're ineligible. You're suspended. It's backwards.
If you're a college sports fan, chances are that you or someone that you know has bought the replica jersey of your favorite college athlete at some point in time. That same player that you idolize also makes no money off of that sale. In contrast, the NCAA and college sports is a multi-billion-dollar business. But this question has been dangling for years. Should the players get a cut? California's Fair Play to Pay Act might change that. So what exactly is the Fair Play to Pay Act? Its formal title is Senate Bill 206, and the newly passed law was signed by California Governor Gavin Newsom recently. The law has gained the support of some of the world's biggest athletes, like LeBron James, who called it a game changer, and even had Newsom on his HBO show The Shop recently to talk about it.
I don't want to say this is checkmate, but this is a major problem for the NCAA. It's going to initiate dozens of other states to introduce similar legislation, and it's going to change college sports for the better by having now the interests, finally, of the athletes on par with the interests of the institutions.
The bill will allow college athletes in California the opportunity to make money off of their name, image, and likeness, and to sign with a licensed agent, two things that in the past the NCAA has prohibited.
The offensive lineman, especially the second, third string guy, this is not going to help them. But who is probably going to help more than anybody else besides the superstars are the tennis players and swimmers, people who can give kind of one-on-one instruction, who can have camps, those sorts of things. So there's some monetization kind of opportunities for those kinds of sports.
The NCAA issued its own statement in response to SB 206, calling the law, quote, unconstitutional and harmful, and arguing that SB 206, quote, would erase the critical distinction between college and professional athletics, and because it gives those schools an unfair recruiting advantage, would result in them eventually being unable to compete in NCAA competitions. Another layer in this discussion is whether or not this law would give California schools a leg up when it comes to recruiting. In fact, before the bill was even passed, Ohio State Athletic Director Gene Smith said the Buckeyes potentially wouldn't schedule any California schools in the future. And in a USA Today interview, Smith said that he would be interested to see how the Pac-12 would handle competition in the conference because, quote, those schools will compete against those schools in California who have an unfair advantage because they'll be able to offer student athletes benefits that the other schools will not be able to offer. NCAA President Mark Emmert also voiced his concerns in a recent IndyStar interview, saying, quote, this is just a new form of professionalism and a different way of converting students into employees. Here are two major points to clear up about SB 206. One, it won't go into effect right away. In fact, it's not slated to go into effect until January 1st, 2023. And two, the California schools won't be the ones paying these student athletes. These financial opportunities under SB 206 fall outside of what we know as traditional NCAA-approved compensation, like a Division I scholarship that may cover tuition, room and board, or other costs for a student athlete. While there are both critics and supporters of the Fair Play to Pay Act, it's a milestone moment in college sports.
Almost immediately, more state legislatures began to discuss this topic and to propose laws to deal with this. It's really the beginning, tip of the iceberg kind of thing.
I love player-friendly things that put people in positions to be successful and to get what they're owed and deserved.